All right, welcome everyone. Thank you for joining us for what we hear is the last panel of the day for our RightsCon online, or maybe it's early in the morning, wherever you're joining us from. This panel is SLAPP, but not silence, fighting state and corporate repression, empowering people. It's hosted by the Protect the Protest Task Force and the Business and Human Rights Resource Center. My name is Abby Henderson. I'm an advocacy counsel at a Washington, D.C. organization called the International Corporate Accountability Roundtable, or ICAR, and I coordinate the Protect the Protest Task Force, which is one of the hosts of this session and is a US-based coalition of organizations that's committed to combating the threat of strategic lawsuits against public participation, or SLAPP lawsuits, in the United States. I'll be facilitating our session today. As our title suggests, today we're going to be talking about lawsuits that are brought by corporations and governments to silence criticism or advocacy, or SLAPPs, as I said. Maybe many of you know someone or yourself have been threatened or affected in some way by these lawsuits. After hearing firsthand stories and learning resilience techniques from our amazing panelists today, we hope that you'll leave this session with the tools to understand and fight off these insidious lawsuits. We're grateful to have with us today three amazing panelists. First, Lady Nancy Zuluaga, who is a legal researcher with the Business and Human Rights Resource Center, where she leads their research on SLAPPs and supports the civic freedoms and human rights defenders and corporate legal accountability programs. Then we'll be hearing from Sutari Wanasiri, a human rights defender and researcher who was slapped for sharing a video on her Twitter about labor rights abuses within a poultry company. And finally, Lauren Regan, who is the founder and executive director and lead attorney at the Civil Liberties Defense Center in Eugene, Oregon. Lauren also leads our legal working group for the Protect the Protest Task Force. Tonight, we're going to first hear from Lady, then Sutari, then Lauren. Lady, take it away.
Thank you so much, Abby, for your introduction, and welcome to all the participants. I'm so excited to be part of this important discussion. I'm going to give an overview of our SLAPPs project at the Resource Center and provide some of our initial findings. At the Resource Center, we are currently undertaking a global SLAPPs project that highlights this growing phenomenon of SLAPPs and aims to produce an accessible database with cases, centralize information about SLAPPs, amplify global collective action, and support human rights defenders and civil society organizations across the globe in fighting against SLAPPs. In our project, we are seeing SLAPPs as a form of judicial harassment that include lawsuits filed or initiated by the private party with intention to intimidate and harass human rights defenders who are engaged in acts of public participation, including criticism or opposition concerning business activities. These lawsuits include civil and criminal cases and are usually brought, among others, against indigenous and Afro-descendant communities, environmental groups, journalists, and labor rights defenders. Before going into detail on our initial findings, I think it's very important to highlight some of the SLAPPs' consequences. First, SLAPPs usually drain the resources of the defenders, often causing financial and psychological impacts. Also, these lawsuits can take years and could have negative consequences on the defenders' work by affecting and destroying not only their reputation, but also making the defenders' colleagues and partners afraid to associate or work with them. Finally, SLAPPs put significant pressure on public resources and force the judicial system to waste their time on superfluous legal processes. So now, in terms of our findings, this project started last year, and we already record around 179 cases from 2015 so far. This number includes around 83 cases in the Americas, 43 in Asia, 33 in Europe, and 20 in Africa. With this amount of cases, we already observe some important trends globally in terms of the defenders being target, sectors using SLAPPs, type of lawsuit, and the most common legal argument used by the plaintiff. In terms of the defenders affected, we identified that at least 126 cases target environmental and land rights defenders. These represent the 70% of the total number of cases, and this is quite scary. In terms of the sectors, around 60 of the cases are related to agriculture and livestock, and 50 with mining. Thus, between these two sectors, we have around the 61% of the total number of cases. Just to mention that sectors such as logging, lumber, oil, and gas have also been using SLAPPs. Now, and very important, in terms of the type of lawsuit, around 103 cases are based on criminal complaints. So this means that more than half of the cases are based on that. 63 are civil cases, and the remaining 23 are a combination of civil and criminal cases. The most common legal arguments are defamation and libel, also damages, usurpation of land, computer-related crimes that are very common in Asia, for example. To finalize with these trends, we also see that plaintiffs usually seek exorbitant damages. And since many cases are criminal, we found that they include long prison sentences. And this is very common in the Global South, particularly in Latin America and in Asia. Just to conclude with this overview, I want to emphasize that SLAPPs constitute a powerful attack to silence the defenders and is a clear violation of the human rights. For this reason, we recognize the important role that business, investors, and governments play in creating a safe environment for human rights defenders, and we think it is crucial to raise awareness about the SLAPPs. This is why this session is very important. So I will leave here, and I know there are so many issues and questions to address, and hopefully we will have time during this session. Thank you, and over to you, Abby.
Thank you for that overview, lady. Next, we're going to hear from Sutari, her firsthand account of her experience being slapped. Sutari?
Thank you very much, Abby, for the introduction, and thank you to the Protect the Protest Task Force and Business and Human Rights Resource Center for this opportunity to speak and share the experience and the struggle that we have here in Thailand. My name is Sutari. I work now as a researcher on human rights and political issues. Previously, I was working with a human rights organization as a researcher. And back in October 2018, I have been facing 3 different lawsuits brought by a company based in Thailand. It's a chicken farm company. So this lawsuit, 2 of them are criminal prosecution, and one of them is a civil lawsuit. In the civil lawsuit, the company demands 5 million Thai baht as a defamation damage to the reputation of the company. So how does it come to this? When I was working as a researcher, I also share different materials, including advocacy, campaigns, and materials online. I use Twitter as a way of communicate the work. I shared a video clip produced by the organization that I work with at that time about a labor rights abuse that took place in this chicken farm. In that video, the workers explain about their underweight, under the minimum wage payments, and the long working hours that they have to do while working in the farm. And after the worker submit a complaint to the authority, instead of being compensated and being remedy, they themselves are also facing the lawsuit from the company for speaking up about the abuse. So I was documented that abuse and also sharing it online, and that's how the company start to target like other people and other activists and also NGO who help the worker bringing justice and compensation to the rights abuse that they face. So in this lawsuit, in total, so far it took 18 months. And it was just read out the verdict in the past months. For the verdict of the criminal defamation case, I was facing the case with one of the workers who gave the interview in the video that we share online. So in this, the court judgment, the court acquitted both myself and the worker, Mr. Nanwin. Then the court mentioned that it was because Mr. Nanwin is defending his legitimate interest while, as a worker who were mistreated when he was working in the farm. And I, as a person who shared his story, the video about his interview, I was disseminating the issue that is considered a public interest because it's a labor rights issue, and that the court acquitted us on that ground. But as Nancy has mentioned, it is not that simple and easy to come to reach this verdict. It took us 18 months back and forth in the court. And we have to to find the resource, like financial resource, time, lawyer, like several, like more than like a dozen of the lawyer meeting in order to come to this point. And this company is not alone in the way that they are using this tactic. This company is itself have so far since 2016 filing 39 complaints against 23 people, including workers, human rights defender, journalists, and also the media company. Actually, today, the court is going to read out the verdict on defamation case that the company brought against one of the media company. So for the situation in Thailand, I would say that the SLAPP lawsuit itself involved not only the company, but because the close connection and tie between the business and the governments and the business and the security force, there are issues of the SLAPP lawsuit that have also involved or have brought up by prosecutor or police as well. For the Human Rights Lawyer Association, they also documented the SLAPP lawsuit in Thailand, and since 1997 until 2018, they have documented at least 212 cases related to the attempts of the authority or the company that try to silence the people who speak up to protect the interest. So interestingly, 23% of the targets in this lawsuit are community-based workers and defender. 16% are human rights defender, and about 27% are activists that are working on political and democratic issues. And interestingly as well, based on the Human Rights Lawyer Association report, 25% of the SLAPP case in Thailand involve expression opinion online. So what I would like to highlight is that the online channel, which has also become a channel that several like environmental defender, workers, and other marginalized community have turned to use, has become also the place where they are receiving more risk for facing this lawsuit. I think I would like to share this at this point, and if there is other issue, I'll share with you all more later.
Awesome, thank you so much for sharing, Sutari. I think we're so glad to have you on our panel because you were slapped for sharing a video on Twitter, and I think in the age of social distancing, the civil society community has only kind of doubled down on our use of these digital tools like Twitter to get our message out, when we're not feeling like it's safe for us to be in the streets or doing any other kinds of direct action. So that's why we wanted to take a large bulk of our time to hear from Lauren Regan to get a training on SLAPP suits and build some resilience against this tactic that we know companies like the one that targeted you can use this tactic time and time again. So let's hear from Lauren.
Thanks, Abby. And thanks everybody for being here. So as Abby mentioned, I'm going to sort of focus on what we can do in order to try to armor ourselves against SLAPP suits, because in general, we call them SLAPP suits because they are frivolous lawsuits. Normally, it's not that you did anything wrong, especially legally, in order to get yourself sued. Normally, what you've done is effective advocacy. We often joke that people who are slapped are kind of wearing a badge of honor because it usually means that they were doing great work and they were really effective, and their opposition, their adversaries, were trying to derail the momentum of their campaign or of their organizing work. Here in the US, SLAPP suits generally pertain to civil lawsuits. We don't normally see a criminal action being labeled as a SLAPP suit in the US. And when we think about online activism in particular, to sort of pick up on Abby and Sutari's point, here in the US, the majority of online related SLAPP suits come from commercial type aspects like Yelp reviews and things like that. But there have been several cases focused on activism that also pertain to SLAPP suits. So before we dive into how to make yourself a little more resilient to being slapped, or how to potentially prevent damage in the event that the bully does frivolously hail you into court, I think it's important to start off by at least mentioning why SLAPP suits are used, and why they may work. I think as Lady mentioned, the number one reason that we see SLAPP suits, at least in the US, by big corporations, especially the fossil fuel industry, is, major in this. But, as she mentioned from her data, we predominantly see it in the environmental and climate movement situation. And the primary motivation there is to intimidate and silence the voices of activists. And not only the target of the lawsuit, but as she mentioned, the idea is to chill everyone around that person. They only need to sue a single individual, and an entire community or a movement starts worrying about whether or not they're going to be next. And that kind of chill, that kind of intimidation can cause people to decide not to be activists, or maybe they're going to back away from the aggressiveness of their campaign or the type of tactics that they might use that would otherwise be completely protected speech and advocacy under their state or federal laws. The other reason, akin to that, is to try and isolate activists from each other. As Lady mentioned, an unfortunate consequence of SLAPP suits is that the person that is slapped becomes sort of an untouchable situation where people don't want to be associated with that person for fear that they might get a subpoena or they might become part of the case. And so the person that is the target of a frivolous lawsuit ends up feeling isolated. It may scare off supporters. It may scare off funders. And all of this is really known by the bullies that are filing these cases. We often are trying to talk with foundations and funders to say, the worst thing you could do is withdraw your support from this organization or this campaign because they've been slapped. If you do that, that teaches these bullies that this tactic is effective, and you will see it a lot more, including, in several SLAPP suits in the US where they've also named foundations and funders as defendants in order to really, kind of precipitate that belief. As Sutari mentioned, another intention is definitely to divert resources, not only staff time, but also money for lawyers, money to get fancy software to go through every email you've ever sent on a given topic, et cetera, et cetera. So resources can be a big issue as well. And then they basically are trying to take what is normally a political dispute, what is normally a debate and a civic discussion, and they try to hail it into court. And especially with the fossil fuel industry and the extractive industries, they are losing in the public opinion courtroom. Most people need clean water and air to breathe and are going to side with campaigners and activists rather than the bazillion dollar, rich corporations that are killing people. And so in order to try to level that playing field, they are trying to take it into the courtroom and paint activists as terrorists or, as these evildoers in order to try to manipulate the media and the public perceptions of things. And sometimes, even just the threat of a lawsuit is enough to, silence dissent, to make people change their tactics. So that's kind of an important understanding, because once I kind of go through a few tips and traps, I will circle back around again that, one of the best things that we can do to prevent SLAPP suits is to make sure that these bullies do not see this as an effective tactic for them. And sometimes that may mean that we have to pretend like it doesn't stress us out to be sued, and it's not slowing our campaign down. We might have to work double the number of hours because we have to work on this lawsuit and we have to do all our other work. But it's really important that we turn the table on these corporations and on these, plaintiffs, on the initiators of these lawsuits, and make them really regret using this as a tactic and using this in the public domain. So, next thing I want to talk about is what you can do to kind of minimize risk. And protecttheprotest.org is our website, and a bunch of resources and some of these tips are on that website. So first thing to know is you want to make sure that you speak the truth. You want to make sure, especially with written statements, that your statements are accurate. You want to make sure that you keep records of any sources that you're using for statements. And especially for more controversial statements. You may even want to use footnotes in your, online statement, in your tweet. Well, you can't really do it in a tweet, I guess, but by putting footnotes in your written work and actually publishing the source material, whether it's a document or another website or something along those lines, it really kind of takes the wind out of the sails of that bully. If you are showing on the face of your document or on the face of your annual report or your web post that you have documentation, factual documentation for your statements, it's going to be much harder for them to accuse you of something like defamation. The definition of defamation, at least in the US, is knowingly telling a lie about someone or something that causes economic harm. So you have to know that the statement is false and it has to cause economic harm. I'm sure different countries, different states have slightly different definitions, but generally I would say that's defamation. So by citing your sources, you're kind of showing like, this is not a knowingly false statement. Make sure that you've got good policies and best practices in place. If you're an organization, even if you're an individual, you want to make sure that you have some social media policies. You want to make sure that you're not reposting potentially defamatory content. You might want to source check anything that you are reposting on, especially on your organizational social media. Because that can get into problems. You want to remain involved in your campaign. Don't hide or stop doing your advocacy. You may want to have media spokespeople using aliases. At least in the US, it's completely legal for me to use a fake name to the media or online. And the reason that is sometimes advisable is it makes it just a little harder for these bad dudes to name you as a defendant in a SLAPP suit. My name obviously is Lauren Regan, but there's no reason that I can't call myself Mary Smith on a website or to the media where I'm going to be quoted if I know that the topic or the area that I'm speaking about is maybe a highly contentious or highly slappable, area. So the important thing, though, of course, is that you have to use that alias starting early in your campaign. So if you're coming up with a new campaign, that would be the time to potentially use a pseudonym if that would better protect you. Seek legal advice early and often. Develop relationships with lawyers that might be willing to take 5 minutes to give you some pre-publication legal review. This is one thing that the PTP Coalition does pretty regularly, which is, I jokingly call this, putting lawyer eyeballs on potentially controversial work product. We'll just take a look at it. If it slides toward defamation or might cause you some kind of legal problem, we can at least point that out before you publish it and before you get into hot water. And obviously, again, the more likely, the situation of potential lawsuit might be, the better. Although, you really never know. We actually defended an organization that got sued by a logging company for calling them forest destroyers. One would think that a multinational corporation, would have thicker skin than that, but that was literally the primary claim for a defamation action in federal court. Check your insurance coverage if you have it. Meaning, this is just a feeling of confidence for yourself. Hopefully you're not going to get sued. And hopefully if you do get sued, you're going to win and they're not going to get any money. But if you know that your assets are secure, or you know that your organization's insurance or your own private insurance would cover you in the event that you are sued for a tort like defamation, then it's just sort of a feeling of armor, like you've done everything you can to kind of help bolster your resiliency. And then the final thing that I really want to focus on for these tips is with regard to document destruction and retention. The reason that this is so important is if you are sued and the case doesn't get thrown out quickly, which we hope it does, but as you've just heard, these things can go on for a long time. One potential damaging consequence is if the discovery process begins. This is where the plaintiff corporation starts asking you for all of your documents, your strategic plans, your membership lists, who funds you, all your emails, your text messages, your calendars. You'd be amazed at the breadth of information that your adversary wants to get their hands on. And normally it's so that they can try to predict who your next targets might be and how they can basically destroy you. And so by having a document destruction policy, the idea is if a document or record does not exist, then you do not have to give it to the bad guys. And unfortunately, many of us tend to have inboxes that we haven't managed in a very long time. You've saved every scrap of paper since Y2K. And all of those documents and records become vulnerabilities to you in the event that your adversary starts making demands. But if you're following a document destruction policy, and it's not a document that your government or the law requires you to keep, then making sure that you've got a nice trim inbox and that you regularly shred old papers that are no longer needed to be retained is important. And a lot of people tend, especially in the NGO world, in the nonprofit world, tend to try and memorialize every meeting, every phone call, everything, and keep it as a document or a record. That also becomes a vulnerability. By having a conversation with someone, there is no record of it. And so the bad guys cannot get your thoughts and ideas and dreams and aspirations as they can when you save it on your computer or you send it as an email or something else like that. So at my organization's website, cldc.org, there are a number of different types of document retention and destruction policies in our tab that's called Take Yourself Seriously. And the reason we named it that is because, when you're going up against these big industries and these big corporations and you want to win, they're taking you very seriously. They're taking you as one of the number one threats against the profitability of their corporation. And they're going to use that money and power in order to try to destroy you or to handicap you at least. And so if that's their intent, you need to up your game. You need to take yourself more seriously and meet your enemy nose to nose in a way that is going to end up being effective for your campaign and will enable you, longevity in whatever movement you're working in. So, and that's not, and there's a important caveat to this. If you have been threatened with a lawsuit in writing, usually, you normally, and every country has maybe different laws about this, but once you get told that you're being sued, you are no longer allowed to destroy anything at all. Once they put you on notice that a lawsuit is pending or, they're dreaming of one, if you destroy documents and records after that second, then you can have civil and criminal penalties potentially for doing so. So once you get sued, it's too late. The same with your assets. Once you get sued, it's too late to move your assets around either. But if you plan ahead and you take yourself seriously and you make sure your documents and your emails and your assets are all taken care of before you get a knock on the door or a lawsuit is filed against you, then in most countries, it's totally legal. This includes things that you keep on the cloud, things that you keep on a server, et cetera, et cetera. And as I mentioned, social media posts are part of this, calendars, texts, emails. But look to your state and federal laws for what you are required to keep and for how long. For instance, payroll records, certain documents you have to keep for a long time sometimes. But things that you can let go of, we really suggest that you let go. Once you are put on notice of a lawsuit, then do what's called a litigation hold, which means anything related to that lawsuit topic should be put in a special folder. Normally, at least in the US and a lot of countries, any communications between a lawyer and yourself for the purposes of getting legal advice would later on be privileged. So if an organization has some real spicy memo that they want to publish, if they send it to me for pre-publication review, and I'm giving them legal advice about the content of that letter, then that document can go in a special folder on their computer called attorney-client privileged. And any documents that they want me to see related to that also may become privileged. So you'll need to look at your own rules of the road for that type of thing. But putting things in your attorney-client privileged folder, as long as your lawyer really does look at them, can be important. If you are slapped, as soon as you get wind that there's a lawsuit afoot, the first thing to definitely do is to get a lawyer as soon as possible. And ideally a lawyer that has some experience in dealing with SLAPP suits, that has some political orientation. A lot of mainstream lawyers are going to tell you, oh, you're being sued, shut your mouth, close up your office, don't do a thing, go to sleep. And obviously, as I just told you, in the SLAPP realm, that is like the opposite of what any activist lawyer is going to tell you to do. So you want to make sure you get somebody with some context. And, you want to be loud and proud about it. You want to kind of shame that corporation for suing you. And you want to make sure that the bully knows that you're not going to be silenced and you're not going to stop your campaign work. So I think that's probably about it for the tips. In terms of online stuff, the one other thing that I would just sort of mention is if you are posting controversial materials, tweets, etc., you may want to take screenshots of certain things and save them, in that attorney folder, just so that, if the universe melts down, you will, have records of things that you might wish that you had going on, you had saved. In the US, we have state anti-SLAPP laws. An anti-SLAPP law is basically a process that allows a judge to fast track a lawsuit, meaning if it passes the sniff test, that this is actually First Amendment retaliation, the judge can throw the case out immediately without a single second of discovery happening. It's basically a fast track way to dismiss lawsuits. But in federal court, we don't have an anti-SLAPP lawsuit, and our federal courts are split on whether state SLAPP suits can be used. And so what we find is a lot of the sleazy law firms that are representing these big corporations are doing a lot of what's called forum shopping, meaning they're looking around at what court would best suit their needs, what court might be most friendly to their nefarious intentions, and that's where they're filing the cases. And those are very often courts that don't have these anti-SLAPP laws. So that's a real problem here in the US, which I know oftentimes a lot of other countries look to the US for anti-SLAPP stuff because we are allegedly bastion of First Amendment rights. Ha ha ha. But we still have a long way to go when it comes to anti-SLAPPs and the protection of people's constitutional rights. And especially, as Abby mentioned at the beginning, because we're in a global pandemic and most people are using online forums as their mode of communication, there is a lot more attention being paid to online, communications. And unfortunately, especially on social media, there is a lot of mud being slung back and forth and a lot of lawsuits that are arising as a result of that. So with that, I think we are going to open it up for some questions and discussion.
Yeah, awesome. Thank you, Lauren. And we're doing so great on time. We have plenty of time for questions. So please, if you're listening in, add your questions in the Q&A box, and we'll get to them as they come in. While we kind of see some of those roll in, I'm curious for all of you, but maybe for Sutari and Lady. Sutari, from your perspective, are there any of those tips that Lauren mentioned or things that you learned through the process that you wish you would have done or you did do that were particularly helpful and are kind of should be considered these tactics or actions that are most useful to those who've been affected by SLAPPs? And Lady, please jump in if in your research you've read about some particularly helpful tactics and practices.
Sure. Yeah. Thank you for the question. And I wish I met Lauren maybe 18 months ago. So before all of this legal battle happened, I found your tips and suggestions very, very useful, and many of them some of us might already thought about it, but also many issues that are the document destruction and retention policy. These are quite rarely discussed in the normal NGO setting, I would say. And one thing that I think I would like to add as well is also when especially for those who are working as a researcher or those who are working with the organization as part of the organization member, make sure that your organization do actually have a lawyer to help have the quick access that in any case of this legal battle, the organization is able to support the staff that was facing this lawsuit or working and have to face the lawsuit as a consequence of the work. Because as many of you, as Roland and Lady mentioned, this could be a very lonely and very isolated battle, because you really feel that impact that you have been alienated, or a lot of people do not want to associate with you because they also fear of getting the lawsuit as well. Even for a big organization, I found myself very, very difficult in order to secure the resource to fight this case by myself, basically. So these are something that I would like to share, that would be good to check with the organization that you work with, that you will be protected and you will be support and you have the access to the lawyers when you are talking about or working on advocacy campaign that can be contentious.
Thanks, Abby. So I just want to add a couple of things. Fears is the importance of work together in coalitions to raise awareness about these trends at the local, regional, and international levels. There are very important campaigns in South Africa and in Europe, but that can be an example of this kind of campaigns. And also, I think it's very important to promote anti-SLAPP legislation, because there is a lack of this kind of laws in many countries. In Asia, for example, just Thailand, Philippines, and Indonesia have anti-SLAPP legislation. But for example, in Latin America and in other regions such as Africa, there is a lack of this kind of laws. And maybe something very important, and this is maybe somehow a recommendation for the governments and also for the civil society organization, is carry out trainings for lawyers and judges and even prosecutors, because at the end they have an important role to play in protecting the defenders. So it's very important to promote trainings, to know more about human rights and standards, because they can't protect defenders. So I think these are somehow a recommendation, but also a tools to protect defenders from being slapped.
Yeah, that's two really great points from all of those really great points. I think something that Protect the Protest in the US has really seen as a success is kind of this multi-layered approach, where we have this team of lawyers that's on call and there to help, like Sutari was saying, who have the context that Lauren noted was so important to just like getting in and understanding the context of a community-based action or some kind of movement-based communication, and being able to provide that quick advice. As we know, like campaigns can be like very time sensitive. And what Lady was saying about doing that training aspect, making sure, you're not only taking up the torch of training the civil society actors, but where there are laws that can be used as kind of that defensive weapon, that your legal practitioners and judges know what these laws are meant to protect, and that they are actually doing that. And I think, we have a role to play in that as well.
And that reminds me, Abby, one thing about the coalition and my organization as well, we defend people and organizations that are slapped for free. And we make it really known that if any progressive social change activist or organization is sued like this, we will defend them absolutely for free, so that those bullies know that it will not take a dime of their resources in order to defend themselves in court. And I think, every country could really, it only takes 4 or 5 lawyers, to kind of carry the load and be able to offer that at low cost or free. And I'll also just put out there that, we are always consulting with other lawyers. So if you're watching this and you're a lawyer, or you work with lawyers and they want to get more information or briefs, or, want to talk through a case with us, we're always willing to help. And obviously different countries have different laws, but some of the legal strategies and tactics can be shared and may be quite similar. So we're always willing to help in that way too.
Yeah, definitely. Lauren, we got a question from the audience about how to kind of balance what can often in movements be this important need to preserve historical records, but still proceed in a way that's reducing risk. So that's the topic. I'm going to read the question to you. How would you recommend that folks in the movement who are hopeful for documentation being important as a historical record proceed while also reducing risk? Is it just run everything by a lawyer and keep it in a separate folder? Or is it, you can't stay safe and have this kind of primary source preservation in your archives?
Well, I think that people need to consider what it is that they're saving, and they need to do a threat assessment of the document. If that document in the hands of your enemy would be deeply problematic to your movement, to your long-term strategy and effectiveness, then that's a high-risk document, and you need to really consider whether or not it's necessary to archive or to save. If it's something that you've already published, then obviously there's that's a low threat. And so save that forever if you want to. And I think there's a difference between like your organization's timeline versus the vulnerable community organizers that you are working with on an environmental justice campaign. Where those names and that contact information in the hands of bad people would be incredibly problematic to your organization and to the individuals that would be threatened by that. So, that's kind of part of it. To give you an example of some problematic documents that I've seen, a lot of times, and Lady mentioned working with coalitions. Coalitions tend to be targeted in SLAPP suits here in the US because you can go after one big thing and get a number of organizations, both big and small, often. The small ones are going to have zero resources. The big ones might be well-resourced. And then within that coalition, a lot of them do things by memorandum of agreement or memorandum of understanding, where they are creating a paper trail of who's in charge, who's doing what, who's bringing in the money, who's bringing in the people that are going to get arrested. And all of that spicy detail is exactly what the corporations and their allies want to know and learn. They want to be able to psychologically profile the movement. They want to be able to map a movement. And that information, is highly vulnerable. So I think people just need to really be a little more critical about what they're holding on to and why. I think a lot of people tend to hold on to every one of their handwritten notes, thinking someday they may want to go back and look at that. And I bet 98% of people never actually go back and look at that stuff. But if you get raided by the FBI or the cops, whatever country you're in, or if you end up getting sued and all of a sudden, you have a choice. You can either turn over those documents, or you can potentially be fined, sanctioned, jailed under some kind of contempt of court order for refusing to turn them over. That's really becomes your choice. You either give up the movement and give up that stuff to your enemies, or you are potentially going to jail for refusing to do so, which can cause all sorts of other problems for you and your organization as well. So do the threat assessment, think about, assets, vulnerabilities, threats, mitigation you can do, and then kind of make your decisions accordingly. And, yes, if it's something critically important to hold on to, and it also is highly vulnerable, perhaps it is something that you need to discuss with legal counsel anyway. And when you've discussed it with legal counsel, then it can go in that privileged folder.
Great clarifications and fine points on all sides there. We have two more really good questions. I think, Sutari, in your work, you mentioned that marginalized groups often have less access to internet and have a hard time defending themselves using the internet as a tool. How are different groups affected from a tech perspective?
Sure. So this question is for me, right? I would say that I was able to speaking. I'm able to speaking in front of you today because I'm one of the privileged let's say, privileged activists that can speak English, that have access to the internet, that have access to computer. But the majority of the people and activists who are slapped by this lawsuit, they are community-based human rights defenders, they are indigenous people, they are migrant workers who do not have this access, like the similar access, and who have less resource to find, for example, a competent lawyers. I have documented in the past some cases that the lawyer, as Roland mentioned, that they did not have the political context or do not know, and they simply give the advice like, oh, stop talking, like just don't do any more thing that could bring more damage to the community activists, because like it's not always easy like to find a lawyer that would agree to fight in the same direction that you want to go forward to. And in addition to that, I think like for women's human rights defender, in some cases, it's not only the attacks against the work or the advocacy content that they do, but it's also sometimes involved like derogatory terms or like different like gender based like harassment, like a message that was posted online to the women's human rights activists as well. So I think these are some of the vulnerability and the risk that I found that marginalized people had to face. Yes.
Yeah, thanks for that, Sutari. One final question from the audience, and I know Lauren has an answer to this, so I'll direct it to her, but feel free to jump in if you guys have other thoughts. Someone's curious about cases of slaps against crowdsourcing campaigns where there's not been a single target, and I thought, Lauren, you especially could talk about how these suits have been structured in the US context, at least, to target groups of people much broader than individuals, and how they kind of use individuals in the lawsuits.
Yeah, I mean, as we mentioned at the beginning, SLAPP suits being frivolous, non-meritorious lawsuits are not normally really actually interested in the subject matter of the lawsuit. They're interested in targeting individuals to scare people. And so, normally they are looking for juicy targets, I guess I would say. So if there was a crowdsourced campaign and there were a couple of big named individuals or entities that the bully was interested in targeting or going after, they could potentially name those individuals if their actual names were identifiable. I guess that would be the first issue is, could they actually identify an individual in order to name them? And obviously, we do know that there are ways for governments, law enforcement, corporations to gain access, to IP records and other types of ways to try to identify who posted what. But normally we won't see an entire crowd in a crowdsource named in a SLAPP suit. We'll see a particular target, a single or small group of targets named with the goal of trying to shut down everything else. The other part of it, of course, is, again, that truth is a defense, to most SLAPP suit claims. And so if something is being crowdsourced and it's being cited, or the actual source of the opinion or information is being disclosed, that is obviously protection, regardless of how scintillating the opinion may be. If you've got it sourced and you're saying it in a factual way, then it's probably going to be more protective than others. There used to be a kind of myth that if I post something and I say, I believe, or I feel that blah, 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 kills people, or, something like, some scandalous statement, but I couch it in the words, I believe, or I feel, or it's my belief, or something like that, that somehow that would not rise to the level of a defamation claim. And that's not true. Just because you add those words to a statement, or if you say, like, based on my understanding and belief, I think blah, 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 those types of added words are not going to be protection against a defamation suit, if that is actually going to be brought against you. Does that answer that adequately, or does anybody else have something they want to add to that?
Yeah, could I add something, Abby? Is it possible? Yeah, I saw some of the comments that they said that one of the very important things in this experience, I think, is important for the people who are facing the lawsuit, that that you refuse to be silenced, because that was the main objective of this corporation, is to silencing you and to silencing the movement. But to stand this ground and to fight back, I think it's very important. In my case, like, I was advised by some people who have a good intention that I should simply make an apology and just stop talking about the labor rights condition that related to the business. But when I wait, like, what are the consequences of stop talking and being silenced? It means that in the future, like, other worker would feel uncomfortable to bring any cases of labor right abuse to the public or to the NGO or to the authority, and that would mean that the labor rights condition will stay in a very bad condition forever, because people fear that if you who are already in some privileged position, you could not even talk or decide to speak about it, then people who are more vulnerable, who have less resource, it would create even more chilling effect on that. And it's like, I think it's like, this is the intimidation tactic, and if you refuse to submit to this injustice, like, is also part of reclaiming your own strength and your own dignity as well, in order to be able to fight and to find the resource and to find a good lawyer to fight with you, to stand up and assert that you were speaking the truth and these are the truth that you want to stand for it. So this is something that I think I would like to share.
Well, I was going to come to you all for some final thoughts. I still will, though I think those were some pretty powerful words there from Sutari. Why don't we go Lady, Lauren, and then Sutari for any final points that you wanted to make for the folks listening about SLAPP suits, any tips you want to highlight, or just final words. Lady?
Thanks, Abby and Lorraine and Sutari. This was very, very interesting, and I learned a lot from you. I just want to maybe say a couple of things about the importance of the involvement of government in not only implementing a strong and good legal frameworks in protecting human rights defenders, but also encourage business to protect the defenders and to include the prohibition of using the SLAPP. Is not only about promoting legal frameworks, but also the prohibition of using SLAPPs. And also, I just wanted to mention that the Resource Center has produced a couple of reports this year, and you can check on our website and see an important report in Asia that we just released this year that include recommendations to government, investors, the companies, and also the civil society. And also there are a couple of cases, study cases in Asia. And also last year we released a report that also include other cases in Africa and Latin America. So if you wonder about some cases, you can check those reports and learn a little bit more about the SLAPPs. Thank you, Abby.
Well, okay. So I guess one thing that I will just mention briefly is, we've sort of been talking about activists being on the defensive, being defendants in these SLAPP suits. But it is also important for us to think about how can we go on the offensive and fight back against the chilling effects of SLAPP suits. And so we represented a group of 80-year-old mayors and city councilors who were sued by Roseburg Forest Products for daring to try to protect their drinking water source in this little tiny town. And we ended up getting the case thrown out as a SLAPP suit. And the timber company ended up paying our attorney fees and costs under an anti-SLAPP statute, which that would have been, a victory under most circumstances. But we were really thinking about what can we do in order to prevent this type of case from happening to other advocates and activists as well. And so a couple of months ago, we actually filed a lawsuit against the law firm that brought the SLAPP suit against these individuals. And we're going after the lawyers for filing a frivolous SLAPP suit against activists, citizen activists, because there was no legal merit to any of the claims. And lawyers like them are making a bunch of money from their bully clients and abusing the legal system in this way. And so we think by going after the pocketbooks of the law firm and making that law firm, accountable for the abuses that it precipitated, that will hopefully teach other sleazy law firms that do this kind of stuff that they could be next. And that maybe, this as a tactic for their bully clients might actually prove to be problematic for them as well. So I would just say, we don't have to think of ourselves as the victims. We don't have to act from our heels all the time. There are some really powerful ways that as smarty pants organizers and activists, we can come up with ways to basically try to shut down this abuse, of our social justice system now and into the future.
Yes, thank you so much, Lauren. Sutari.
Thank you, Abby. So I think last thing that I would like to mention is also it's important to know your allies and to keep your allies and your partner engaged in this fight, in this lawsuit and in the campaign. And you should also try to broaden that issue in the sense that it's not only targeting only one specific human rights issue, but it's actually very broad based. So environmental activists, labor rights activists, media freedom activists, all of them are being subject to this lawsuit. So in terms of fighting back this SLAPP lawsuit is important to broaden that alliance. Thank you.
Yes, awesome. So great. I think this has been a really spectacular hour with all of you. I want to thank our awesome panelists. I want to thank the RightsCon and Access Now team for pivoting during a global pandemic to an online platform. Totally phenomenal. Have been nothing but helpful. Our awesome technical moderator, Jesus, who's been behind the scenes the whole time, making sure that we stayed technically connected to you and we got all your questions answered. I have been so inspired by working on SLAPPs and judicial harassment in the US and around the globe. And I think the key takeaway for me is that, yes, this is a bullying tactic, but if everyone is playing their role, this is a tactic that doesn't have to exist. As Lady highlighted, governments and businesses have a role to play by passing laws and committing not to use this tactic against communities who are just trying to say, hey, you know, I need clean drinking water like your family needs clean drinking water. Don't pollute my drinking water source. It takes lawyers who are plugged in and know what is going on and what are the risks, and they're able to act quickly and help out and think smart about legal strategies, and who are committed to not taking on clients or to suggesting to their clients that SLAPPs are a tactic that they are willing to use in the legal profession. And then it takes activists and community organizers and civil society members standing in solidarity with our partners when they are threatened with these. And the tagline that we like to use at Protect the Protest is an attack on one is an attack on all. And I think there's so much power in that statement. And so that's something we've been really trying to live in how we respond and proactively respond to the threat of SLAPPs. I want to ask Lauren to share her screen with the PTP contact information one more time, so we leave that up as people leave us to go to sleep or to go to work. And I want to note that Jesus has put Lady's email address in the chat for you all, and please reach out if you're interested in creating a Protect the Protest type coalition in your country. If you have questions, we'll try to get answers for you. If you have case studies of SLAPPs that the business and human rights corporate accountability community should know about, send those to Lady. And I think that's it. Thank you all so much. This was a great session.